Thank you, Mr. Chair and members. SB 1063 prohibits employers from paying employees a wage rate less than the rate paid to employees of a different race or ethnicity for substantially similar work. Despite being the most diverse and prosperous state in the nation, many California workers continue to suffer from a chronic racial and ethnic wage gap. Last year, my colleague, Senator Jackson, began to address wage inequality by prohibiting employers from paying employees a wage rate less than the rate paid to employees of an opposite sex for substantially similar work. Senator Jackson, the leader in this effort, stood on the Senate floor this past Monday recognizing Equal Pay Day. Senator Jackson, you are correct. And we thank you for your work in this area and being a leader in this area. And you are absolutely right. We do need equal pay in the state and in the nation. Members, we also need to acknowledge that pay inequity is not limited to sex or of a worker, and I would encourage you to co-author this important legislation with me. Members, in spite of the recent passage of SB 358, wage inequality is still persistent in our state and in our country. Data released by the National Women's Law Center on April 4th of this year found that African-American women make 83 cents for every dollar white women make. Latinas make 57 cents for every dollar white women make. African-American men earn just 75 cents for every dollar white men make. And this is in addition to data from the American Association of University Women that found Latina women make 43 cents for every dollar a white man makes, and African-American women make 63 cents for every dollar a white man makes. And members, this is unacceptable, it's un-Californian, it's un-American, and no employee should be denied an equal wage for an equal day's work, regardless of your race. SB 1063 builds upon the important steps California has taken to address wage inequality and will set a new national standard to ensure that every worker is paid a fair wage and equitable wage. I respectfully ask for your aye vote. We have Geraldine Stapleton from the California National Organization of Women, which is a sponsor, and also Mariko Yoshihara from California Employment Lawyers Association present to testify in favor of this legislation.
Wonderful. Witnesses in support, please speak.
Hi, my name is Geraldine Stapleton. I am the president of California Now, which is the national organization for women because it includes men. Okay, not it's for. And anyway, have a membership of over 400,000 members. It is the largest women's rights organization. We have 6 core issues, which are reproductive rights and justice, economic justice, ending violence against women, racial justice, LGBTQ rights, and constitutional equality. SB 1063, the Wage Equality Act of 2016, would address 3 of these core issues: economic justice, racial justice, and equality. And we'd like to thank Senator Hall and his staff for introducing the bill to expand the Equal Pay Act to include race and ethnicity. California Now is a membership organization committed to institutionalizing intersectional gender equality. Our work transgresses over social boundaries and built walls built to imprint, reinforce, and protect implicit stereotype biases that damage all of us. We are here to make these changes happen by working with progressive intersectional feminist lawmakers like Senator Hall, by broadening all claimants to include all forms of indigenous wage discrimination. Such broadening is necessary so that all women and men, for that matter, are recognized as having a right to equal pay for equal work. As it stands currently, the California Pay Act fails to include the largest factor for inequity, that of race, effectively limiting redress for compensation differentials to a select group of women workers. As it's well known that women of color have been receiving a wage rate much lower than white women. White women have gone from 59 cents 30 years ago to big 79 cents. Some studies say 84 cents on the dollar a white man earns. And African-American women receive 64 cents. Latina women, 54 cents. In some studies I've read as low as 44 cents. And because race is the largest factor for discrimination and inequality, SB 1063 would address those issues. The median income for LA's Latinos is $21,314, while for whites it's $44,929. African Americans are said to make $31,603, and the U.S. Census says that the median individual per capita income in LA County is $27,900 a year. Latinos and African Americans still earn lower hourly wages than whites in California, according to a study released by the Public Policy Institute of California, PPIC. And according to the Institute for Women's Policy Research, four of the most common occupations for women employing 5.7% of all full-time working women, cashiers, maids, and household cleaners, waiters and waitresses, and personal care aides, have a median weekly earnings for women for a full week of work that are lower than 100% of the federal poverty threshold for a family of four. Intersectionality is the theory of how different types of discrimination interact. More precisely, intersectionality is a concept about how an individual can face multiple threats of discrimination when their identities overlap a number of minority classes such as race, gender, age, ethnicity, health, and other characteristics. More importantly, intersectionality describes the hierarchical nature of power and how belonging to multiple discriminated classes can mean that once issues are ignored, which leads us to today's hearing of the Wage Equality Act of 2016, a bill that expands the scope of the California Pay Act. And we would like to commend Senator Jackson for SB 358, the California Pay Act, now law, as it goes a long way in addressing the substantial inequalities of the original Equal Pay Act's elements and defenses. However, these improvements must be accompanied by the pay gap compared to white men is larger for women of color and women from immigrant and refugee communities, leading to a significant lifetime losses to the higher poverty rates that a lot of people, women, when they go to retire, have less money for retirement. They've had less money to, contribute, to the overall economic issues into our society. California Now, because we are a progressive intersectional feminist organization, we advocate for solutions that recognize that individuals face multiple intersecting discriminations or privileges based on race, sex, gender, sexuality, disability, and other statuses. Each and every one of us should be working to eliminate individual and institutional privilege, discrimination, and bias. So that's why we are here today in support of SB 1063, Senator Isidore Hurl's bill that adds race and ethnicity to the Equal Pay Act. We stand in support because this bill begins a process of full inclusion, and with it the recognition that everyone has a right to equal pay for equal work. We strongly urge you to pass this bill, 1063. Thank you.
Others in support?
Thank you, Mr. Chair and members. Mariko Yoshihara with the California Employment Lawyers Association. We were co-sponsors of the Fair Pay Act last year, authored by Senator Jackson, and we're happy to see Senator Hall building upon this great achievement to add race and ethnicity to the Equal Pay Act. So the problem with attacking pay discrimination through our anti-discrimination laws under the Fair Employment and Housing Act is that it requires workers to prove that the employer discriminated against the worker based on race and/or gender. And this is the problem that we were trying to address last year with the Fair Pay Act. What numerous studies have shown is that after accounting for factors like age, education, experience, there's still a significant wage gap that is unexplained. And studies also show that many decisions are based on implicit or unconscious biases rather than overt discriminatory motives. So this reality makes it extremely difficult to address wage inequities under our anti-discrimination laws because, again, you have to show discriminatory intent. This is why the Equal Pay Act is such an important tool, because rather than putting the burden on the employee to prove discriminatory intent, the burden is instead on the employer to provide some legitimate business purpose that can explain the wage differential for employees who are doing substantially similar work. And since the Fair Pay Act was enacted, we have heard from many attorneys that employers are actually self-auditing their payroll data to ensure that there are no unexplained wage differentials and that their workers are being paid fairly. And we think that the result of this this bill will be a similar analysis by employers. Well, they will look at their pay data to ensure that there are no unfair wage differentials that could in fact be attributed to race or ethnicity. And in fact, the DOL is currently promulgating regulations that will require large employers to break down payroll data, not just based on gender, but also based on race. And Assemblymember Dodd also has a similar bill that would require the same type of data. So it's important to remember that the Equal Pay Act is a wage statute under the Labor Code, as opposed to our anti-discrimination laws. When you look at how much money workers are losing every year based on the race and/or gender wage gap, this is money that helps support their families, that goes into our economy. It's extremely important that these workers have all the tools necessary that they can recover those lost wages. Or alternatively, that employers are forced to take proactive measures to ensure that all wage differentials are actually accounted for. For these reasons, we are in strong support of this bill and encourage your aye vote.
Okay, thank you. Others in support?
Shannon Smith Crowley, representing the American Association of University Women. We're co-sponsors of the bill. I align myself with the comments of the witnesses. Just one thing I saw yesterday, somebody handed me a document from 1942. And back then, there was women were being paid 92 cents on the dollar. So we've actually kind of gone back a little bit there. And in terms of, this is just something that we need to attack head on, use every tool in our arsenal. And, we can raise a significant amount of poverty. We can reduce the need for the social safety net. We think this is important. And again, as Ms. Yoshihara said, employers are, because of the Jackson bill, taking this amazingly seriously. I'm actually very impressed. And as long as they're already doing these audits, it makes sense to look at all these different factors. As Ms. Yoshihara said, a lot of this isn't probably conscious. It's implicit, it's the system. So helping them by saying, you need to look at X, Y, Z would actually, I think, be helping employers as well. So we ask for your aye vote.
Wonderful. I know we have others in support. Please state your name and organization.
Hi, Jill Rice with the California Federation of Teachers in support.
Mr. Chair, Seth Bramble here for the California Teachers Association in strong support.
Mitch Seaman, California Labor Federation, also in support.
Jessica Stender, Equal Rights Advocates, in support.
Brian Ortiz, ACLU of California, in support.
Joshua Golka with the American Federation of State, County, and Municipal Employees, in support.
Hi, Katie Joaquin with the California Domestic Workers Coalition, and our affiliates that represent house cleaners and nannies and caregivers across the state request your support. Thank you.
Kim Rutledge with UDW, AFSCME Local 3930, in support.
Dania Cassidy, California Work and Family Coalition, in support.
Gina De Silva, California Immigrant Policy Center, in support.
Mi nombre es Carlota y apoyo esta ley. Raquel Botello, apoyo la propuesta.
Blanca Vasquez with the California Domestic Workers Coalition, in support of this bill.
Hola, buenas tardes. María Reyes, organizadora con la Alianza Nacional Trabajadoras del Hogar, y apoyo esta ley.
María Distancia de Oakland, apoyo esta ley.
Christy Baum on behalf of the California Professional Firefighters, in support.
Hi, Megan Whalen with the California Domestic Workers Coalition. I support this bill.
Dalet Santiago de Mujeres Unidas Activas, apoyo la ley.
Alex Rooker with Communication Workers of America, Local 9400, in support.
Thank you. Great. Thank you. Would like any opposition to step forward and please have a seat.
Good morning, committee members. Mr. Chair, Jennifer Brewer on behalf of the California Chamber of Commerce, and we are opposed to this measure. As we stated last year when we were working with Senator Jackson on SB 358, and were urged by members of this committee to deal with that issue, we agree that nobody should be paid differently in the workplace based upon any protected classification, whether it be gender, race, ethnicity,
sexuality, disability, medical condition. I mean, going through the list, that should never be the basis for a wage payment in the workplace, and we completely agree with that. Since, and we worked with Senator Jackson to deal with the gender issue, equal pay, and I want to kind of just highlight something. There's been a lot of statistics out there regarding the differential in pay with regards to Latina women, African American women, white women. The bill last year didn't differentiate between whether you were Latina or African American. It was just gender. And so any woman is protected right now under the equal pay law, regardless of whether you're Latina, African American, white women, et cetera. It didn't speak to race or ethnicity of the actual woman who was being, was at issue with regards to the wage disparity. So I want to just address that issue. The negotiations, the new standards that were put into place with SB 358 were significant. We are as much as invested in making sure that SB 358 works and is something that is a balance between the employee and the employer. We believe that that created the right balance. We believe it addressed the issue of wage disparity in the workplace, and it also potentially helps employers with regards to objective standards that they can comply with in order to make sure that they're not at risk for litigation, penalties, etc. And we are invested in that, and we hope that it works. And we believe it will work. With that said, as soon as SB 358 was passed last year, you saw a ton of media attention, articles, journals, everything by attorneys and employers basically saying this is the toughest equal pay law in the nation, which it probably is. And there are tons of different new standards that have been put into place by this bill that are unknown, that are ambiguous, that employers are concerned with how they're going to be interpreted and implemented by the court, such as what does substantially similar mean? What does the bona fide factors mean? What is a business necessity, and what will qualify for that? Is there other things that an employer can demonstrate or an employee can demonstrate to show that it wasn't a business necessity? And why we think there is case law out there to help interpret and guide the courts on what these standards are, we don't know. There is a test case out there right now dealing with attorneys in the insurance industry that everybody is looking towards right now to see how the court interprets these standards. And once those standards are interpreted and they are determined as to what the meaning is, then I think it is a reasonable thing to sit there and look at whether or not additional protected classifications should be added, whether or not there are things that can be done to address these other things. But right now, it's been in effect for 3 months, and we don't know what those standards are. And so to say that it's just so easy for an employer to go conduct an audit of their payroll practice to mitigate against the potential claim for an unequal pay or wage disparity, it's really challenging right now with the new standards that have been put into place, the toughest equal law in the nation, and having to adjust for that. So I'm not sitting here saying that we think anybody should be paid differently based upon their race or ethnicity. I don't agree with that at all. But what I'm saying is, with the implementation of such a new standard for employers, it's really difficult for them to adjust to that and then continue to add to that before the courts have had an opportunity to address this issue. The other points that were raised about the Department of Labor collecting information, that regulation has not been finalized, and there's a lot of challenges with that, and I just want to briefly speak to it because it was raised by the proponents. The form that is pending before the Department of Labor asks employers to collect data based upon different classifications with regards to wage, with ethnicity, race, gender. And while that is something that is up for discussion with the Department of Labor, one of the main concerns is it doesn't include the list of exceptions as to when there can be a legitimate wage differential, as was included in SB 358. There are definitely employer-specific reasons as to why you may pay somebody differently who is in the same gender for things such as seniority, experience, training, education, and our concern with that form that Department of Labor is promulgating is it doesn't take those legitimate reasons for a wage disparity into consideration. So while they may be proposing that, it certainly hasn't been finalized, and I know there's been a lot of comments submitted by certainly the employer community to have them also include things such as the bona fide factors that Senator Jackson included in SB 358 last year. For those reasons, we are opposed.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. Let me just add 2 additional points. As Senator Jackson and her staff and the Judiciary Committee staff will recall, we spent months coming from a position of opposition to SB 358 to a position of support. There were extensive amendments made by SB 358 to Labor Code Section 1197.5, and we added all sorts of new terms, one of which was raised equal pay equal work is now substantially similar. There are draft FAQs that are available from the DLSC, and here's how they define substantially similar, mostly similar. I'm not sure entirely helpful guidance. As the proponents indicated, the employer community is in fact taking very seriously the significant changes made by SB 358. We need to give that legislation some time and see some court decisions and how some of those terms are going to be fleshed out ultimately, because clearly the guidance from DLSC isn't going to help us. Lastly, please note that under FEHA, there are avenues for relief for people who believe that they are discriminated against based on race or ethnicity. And under FEHA, there are compensatory damages, punitive damages, attorney's fees available. So there are remedies already available. Thank you.
Great, thank you so much. Any other in opposition, please step forward.
Good morning, Mr. Chair and members of the committee. My name is Javier Gonzalez here on behalf of the California Restaurant Association, and we agree with Ms. Barrera in terms that no employee should be paid differently based on their race and ethnicity, but we align our concerns with the Chamber of Commerce, so we urge you to please vote no on this bill.
Nicole Rice, California Manufacturers and Technology Association, for the reason state is also opposed.
Trudy Hughes of the California League of Food Processors in opposition.
Good morning, Chair and members. Tricia Geringer with Agricultural Council of California in opposition.
Wonderful, thank you. Any others in opposition? Seeing none, we'll go ahead and go to comments from members. We'll start with Senator Mitchell.
I just had a quick question. A number of the opponents suggested that the business community was wholly supportive of the bill that's passed on the gender focus, that the lawsuit is currently in process. And so my question is, if that is the case and you're asking that those actions be taken first, I just want a general idea of timing. Is that a year? Is that 5 years? As I just said to Senator Jackson, Dr. King famously said, if not now, when? And so in that it wasn't prudent, it wasn't perceived as prudent to try to wrap it all in the initial bill. The initial bill had broad support. If we are waiting for those ducks to fall in a row, if you will, I'm just curious as about a sense of timing. Is the lawsuit a year out, 2 years out, a decade out? The regulations, please. Because to expect that our norm should be the protections to file once you have been violated, for our norm to be to file suit and have to get damages after the fact is not acceptable to me. Yeah, that is a protection, but that shouldn't be our default norm. So if you could give me a sense of timing.
Sure. The case that I was referencing was actually filed in April of last year. It was amended to include an equal pay claim after SB 358 was placed in January. I believe it has already passed the class certification stage, which means it's obviously well into well into the litigation timeline. And so I would anticipate that you would see a potential decision in maybe a year to 18 months. That's not a guarantee, obviously, with our court system, but I think that you will have some determination, and that's if it proceeds to trial. Now, maybe the case settles out, maybe something happens where it goes away, and that's another consideration to make, but that is the case that I know a lot of people are watching to see what the guidance and the determination is going to be.
And so if it settles, as opposed to going through the complete trial process where we then have some precedent, then what happens? Does a settlement give the business community the kind of guidance that you would need?
Unfortunately, it won't. And so, yeah, so I agree that it wouldn't give the guidance that we're looking for, and whether or not something else pops up, whether it be an opinion letter from the labor commissioner or additional guidance on another case that is working its way through the court that nobody has been aware of yet, that would help us with the guidance that we're looking for to make sure that what we intended when we were negotiating SB 358 with regards to substantially similar business necessity, bona fide factor, is how the courts are interpreting it as well.
Thank you for that clarification. Appreciate it.
Thank you, Senator Mitchell. Any other comments from the committee?
Senator Jackson.
Obviously, this is an issue near and dear to my heart, and I do want to thank the work that was done by the chamber and the other folks in the business community, so that we ended up last year actually getting a bill that everybody supported. We had 118 of 120 members of the legislature who voted aye on that equal pay bill. We had virtually no opposition to it, and that was a very carefully thought out plan where we had the advocacy groups at the table with us every step of the way to get something. The key was, can we get something that will work, that will essentially set the standards that we can then follow? Again, as was referenced, 50% of the population is included in this bill because it's a basis of gender. It doesn't matter what your ethnicity is. If you are a woman, are you being paid less for the work you do based upon factors that are not business necessities, that aren't based upon, we talked about experience, education, productivity, I think was one of them, I'm missing that at the moment, but things that are legitimate business issues. And the goal has been to essentially set the groundwork. And that was the hope and the expectation is that once the business community knows what is expected of them. And I have been very impressed, frankly, to see a number of businesses, Mark Benioff with Salesforce, I know, who is it, a number of other large companies that do business in California, even before the bill was signed into law, and then afterwards have said, we are going to review and create our own matrix to find out how we are, in fact, paying our employees. Are we discriminating? And I know with Salesforce, they identified that their female employees were being paid $3 million less. So we now have some lawsuits because this issue is a matter of some public interest, and even, in fact, the president has called on equal pay. And we have been seeing a number of other states bringing equal pay bills. And so we've got a movement going here. I'm very hopeful that we are going to correct this inequity and all inequities. And I was very pleased to hear the chamber say that they don't believe that there should be discrimination in pay on any basis. And hopefully we will get to that. I will, of course, support this concept, and I will support the bill. My only caution is that we want to make sure that we are moving in a positive direction so that employers know what is expected of them, and I believe they will comply, because I frankly don't believe most employers intentionally discriminate. There are probably some who do, but I think part of this is an implicit or sort of unconscious bias that has been created through generational discrimination that they don't necessarily recognize. So I don't see any bad guys here. I don't want to see any bad guys here. I just want to make sure that the issue doesn't sort of collapse of its own weight. And so that was sort of the basis upon which we did the bill last year. I think we've got some very good opportunities to get that definition, and hope that as we go forward, we continue to recognize that we've got to get everybody working together in this in a way that's very positive. And I think so far it has been, and we need to make sure that balance continues as we move this forward.
Thank you, Senator Jackson. I also will be supporting the bill today, Senator, and as much as our increase in the minimum wage bill was appropriately and accurately framed by the governor as an issue of economic justice, this is certainly also an issue of economic justice.
Thank you, Senator.
And I would, as I did with Senator Jackson's bill, challenge the employer community to find a way to yes, because this is not, if we can all agree this is a real phenomenon, I don't think anyone doubts it. Whether it's implicit or explicitly created, it's a phenomenon. And it is not a phenomenon created by employees.
That's right.
It's unfortunately a phenomenon created by employers. So one way or the other, employers need to get there. And so I think we've got a great model upon which to build, which was SB 358.
Thank you.
So I'll take a motion then from Senator Mitchell. And we will call the roll.
Thank you.
The motion is due pass to appropriations. Mendoza. Stone. Jackson.
Aye.
Jackson, I. Leno.
Aye.
Leno, I. Mitchell. Aye. Mitchell, aye.
We will put that bill on call.
Thank you, Senators.
Thank you, Senator.
Thank you.
It appears that all the remaining bills here are committee authored. It looks like you're about to get to another.
I was actually about to leave. but I'm
Okay.
gonna present my bill if you allow.
You're welcome to. That would be file item number 2, SB 1001 by Senator Mitchell.
Thank you, sir. Thank you.
Welcome, Senator Mitchell.
Thank you, sir. And that's what I hate most about this time of year. Our need to multitask and be more than one place at a time.
It's more than multitasking.
It really is, and I forgot my roller skates at home this morning. I should have put them on. So thank you very much, sir. I'm pleased to be here to present SB 1001. In November of 2014, the President announced an expansion of the existing Deferred Action for Childhood Arrivals, also known as DACA, by removing the age cap as well as creating a new program called the Deferred Action for Parents of Americans, DAPA. Under this program, individuals who came to the U.S. as children and meet DACA eligibility guidelines may qualify for deferred action and may also obtain work authorization. Although this program provides deportation relief and the legal right to work for thousands of families in California, some employers may use this newfound status to discourage or create challenges for potential job applicants. One example of document abuse occurs when a prospective employer asks for an employment authorization document, although the worker has already shown a state identification card and an unrestricted Social Security card, satisfying the requirements of the federal I-9 form. While existing state law prohibits document abuse if it's retaliatory in nature, there is no protection against document abuse at the initial point of an individual's application for employment. Currently, federal law provides protection against document abuse, but these protections must be enforced through an overly cumbersome process, which makes it extremely difficult for potential workers to avail themselves of this remedy. This bill amends the Labor Code to explicitly state that it is an unlawful employment practice to request more or different documents than required by federal law as a prerequisite of employment. This bill also states that it's an unlawful employment practice to deny documents that appear to be genuine or attempt to re-verify or re-investigate an employee's authorization to work. And finally, this bill will also provide the Department of Labor Standards Enforcement the authority to investigate and enforce the prohibition against unfair immigration-related employment practices. We must ensure that Californians who have the legal authorization to work are not subjected to additional obstacles to employment once they provide acceptable documents that establish work authorization. We must not discourage families who have fought to be in proper legal standing to live in the shadows because of these additional obstacles. Amendments were taken in the Senate Judiciary Committee to help to ensure consistency between federal and state definitions and requirements for employment. I have two witnesses here with me today, and I ask for your aye vote.
Thank you, Senator Mitchell. Welcome. Those in support.
I'm Jeanette Sanipatin on behalf of MALDEF, the Mexican American Legal Defense and Educational Fund. I am here as a proud co-sponsor and in support of this bill. Senate Bill 1001 is a really important bill for California. As the author mentioned, we are at a point where potentially a million new workers could be added to the workforce should the Supreme Court decide in our favor in terms of allowing the President's immigration program to move forward this year. And so we potentially have, as I mentioned, 1 million new workers that would be work authorized to work in the state of California. Exactly. And so as a state, we think that it's really important to allow low-wage workers to have access to a remedy that's readily available. Under federal law, the process for a worker to, in order to assert their rights, is really cumbersome. They have to first file with the Office of Special Counsel, which is followed by a review by an administrative law judge, and then the next level of review would be the Court of Appeals. This bill would make it simple by allowing a low-wage worker to apply directly with the Department of Industrial Relations, and that way avail themselves of the remedy. We also think that employers just that are doing the right thing should have no problem with this bill because it's already required under federal law. But it's also important for this new workforce to sort of know what their rights are. Many non-citizens do not know that this is a prohibited employment practice. And so by doing this bill, we hope that not only on the employee end, but also the employers could also revisit sort of their employment practice and ensure that this type of discrimination is not happening in California. I think we stand to benefit by this new workforce and continue along the lines of integrating immigrants in every way that we can as a state. And so I urge your aye vote today. Thank you.
Thank you for your support.
Good morning, committee members. Gina De Silva with the California Immigrant Policy Center. Very proud to co-sponsor this legislation with MALDEF. This addresses a discriminatory practice that critically impacts our immigrant workforce, which is 1/3 of California's workforce, and present in various sectors throughout the state. Due to their status or perceived status, they're often the target of these type of discriminatory practices that can cause workplace confusion or even lost jobs. It really reflects the well-established and clearly defined federal laws that guide the process for employers. Unfortunately, despite that clarity, the Department of Justice in recent trainings has cited document abuse as the #1 issue that impacts our immigrant workforce. And there's clear evidence through the settled cases that there is a discriminatory difference in how employers process citizens versus non-citizens in these types of cases. So we're talking about not just potential DACA recipients, but also green card holders and even naturalized citizens. This would really address the prevalence of the practice by building on the existing protections by making sure within any context that this practice is prohibited in California. We don't want our employers to be acting as immigration agents. We want to ensure that they're following well-established rules that have been in effect for over 30 years because our immigrant workforce, as my colleague mentioned, often are not aware that this practice is unlawful and may just abandon this potential job and the abuse continues. So we must ensure that in California, a state that has such a significant immigrant workforce population, we have a clear state remedy that our employees can access, and we really feel that the bill will further protect our immigrant workers and uphold responsible business practices, and we urge your support. Thank you.
Thank you, Mr. Silva. Others in support of Senator Mitchell's SB 1001?
Mariko Yoshihara with the California Employment Lawyers Association in support.
Thank you.
Mitch Seaman, California Labor Federation, also in support.
Thank you.
Brian Ortiz with the ACLU of California in support.
Thank you, Mr. Ortiz.
Alex Rucker with the Communication Workers of America, Local 9400 in support.
Thank you, Ms. Rucker.
Jessica Stender, Equal Rights Advocates in support.
Thank you, Ms. Stender. Anybody else in support? Analysis does not list anyone in opposition, but we'll offer an opportunity for anyone to express otherwise. Does not look to be so.
Move the bill.
Thank you. We have a motion by Senator Jackson and other comments by the committee. I think proof that this bill is beneficial to both employers as well as potential employees is that there is no opposition listed. I had been unaware of the significance of document abuse until we heard this in Judiciary Committee, so glad to see it here in Labor today. We will call the roll.
Motion is due pass to appropriations. Mendoza? Stone?
No.
Stone, no. Jackson? Aye. Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell?
Aye.
Mitchell, aye.
Thank you, Senator Mitchell. We will put that bill on call.
Thank you, sir.
Thank you. Senator Jackson, you have two bills. No, just one, excuse me. SB 1166, our item number 5.
Great. Thank you.
Thank you.